No, it's tied in there, I think. So. I see. I got dressed in the dark. I can see the inside out. So, Leila, in between dealing with sanctions, how are you keeping? Lot, lots happening. Oh, is it? Okay. Someone I met, someone, oh, I think at Freshfields who had
Neil.
done Turkcell,
Nice to meet you.
they could not still believe that it was going on. Yeah. Is it, I mean, I think she said it must be almost 20 years now.
Yeah. Am I on?
Yeah, I think they were involved in the early stages. But is this the Concorde now? But you're still only on.
Testing. Cool.
Testing.
Yeah.
So, Leanne's here to introduce him,
Okay.
and then we can get on with it. Is that
Okay. Yeah, that's fine. Okay. That's not awesome. Guys, do you mind moving to those so we don't have to kind of talk through this speaker over here? Just concentrate the. How's it, Nicholas? Because you're gonna. You want to? Yeah, go introduce the income back. Okay, no, let's go for it.
he good? All right. All right, good afternoon, everyone. I hope that you had a wonderful lunch and are ready for our next set of sessions. Our session today is titled The Impact of Sanctions on International Arbitration and Enforcement. And today it examines the challenge increasingly shaping cross-border dispute resolution. Now, as sanctions regimes expand and intersect with legal frameworks, they raise critical questions around jurisdiction, compliance, and enforceability. So here to lead this conversation, our moderator, Chandni Gopal, who's a partner at Weber Wenzel. We also have our panelists, Lele Modise, Neil Boyd, and Trevor Versveld. Ladies and gentlemen, please give our panel a warm round of applause as they continue with the session.
Hi, everybody. Thank you so much for joining us today. As our MC so adequately introduced this team, this is a real well-qualified group of people. Lele, you are the Group Chief Legal Regulatory Affairs Officer at MTN. Lele is a really accomplished and well-regarded legal executive at MTN. She provides a lot of strategic counsel on major corporate transactions, M&A, complex regulatory issues, and at least in this context, disputes. And then we've got Neil Boyd, all the way from London, Linklaters, where he is counsel. Neil specializes in complex cross-border disputes with a particular focus on international arbitration and related court proceedings, including investment arbitration. Interestingly, Neil speaks Russian. He spent some time in Moscow, and so he's got some particular expertise with disputes in the CIS region. So we're thinking Eastern Europe and Northern Asia. Then Trevor is my boss. He's also a partner in Weber Wenzel's dispute resolution practice. He's got over 30 years experience in complex and high-profile corporate and commercial dispute resolution, and of course that includes international and domestic commercial arbitrations. So what are we hoping to achieve today? So from a contextual perspective, in an era of geopolitical conflict, you've got an increasing intersection between law and politics. And we're going to try and look at one of those very many intersections, and that's international arbitration and international sanctions. We're going to look at how sanctions can make doing business difficult, how disputes can arise from them, how international arbitration can sort of deal with those challenges, and what we need to do to really make sure that international arbitration is still a viable dispute resolution mechanism in the world of sanctions. We thought that it might be helpful to just give a little broad overview of what sanctions are. You know, speaking very broadly, they're effectively these economic measures that are imposed by states or groups of states on other states or entities or other persons. And really what they're aimed at achieving is a foreign policy objective or security-related objectives. And what they usually look like to those of us reading the news are trade embargoes, asset freezes, travel bans. But what makes sanctions so complicated is that they are by no means homogeneous. They vary from region to region. They vary in terms of enforcement. And so I think it's best if we just go right into it. I guess there is a perception, at least globally, that sanctions could have a chilling effect on the rule of law, the administration of justice. Access to justice is a big one, but probably legal certainty is another issue. So I'm going to let each of our panelists speak to them. But Lele, perhaps we start with you. Is that a valid criticism? How does it affect legal certainty in your neck of the woods?
I mean, we often think about sanctions frameworks as a policy, and I guess at the onset it would have been part of the thinking. But because it involves nation states and it can extend to any area relating to what a company would be offering, like from an MTN perspective, the technology that you use to provide network services. It now moves quickly from being a policy issue to having a direct operational impact. We've seen the developments between the West and the East in relation to chipsets. And before that, although it's not widely felt, for us there were considerations because you would have, one of our vendors had entered into a plea agreement, and I think it was in 2017, and that agreement had as a key term a suspended denial order. However, they breached the terms of the plea agreement and the denial order became active. What that meant is that that particular vendor that provided us with network infrastructure, so the hard and the soft, including the software updates, license management, could no longer assist us because there were US components on there. That also meant that now we have to think about how do we replace that entire stack, and it's not cheap. The swap itself is not cheap, but there are vendors that you can get to do that. Happens to be from the East, and there's this technology war, but you choose that vendor because you know that they are able to meet the standards of operation that you're looking for so that we can all be on our phones. But to be able to swap all of that out actually goes beyond just the cost of it. It goes to how do you then get rid of that equipment. You can't give it to someone else because that's also another breach of the sanctions. And keeping it also has a regulatory requirement. And trading with it without a general license or an approval can be a violation. So there's so many impacts and things to think about from a trade sanctions perspective. It has an operational impact, but it also has obviously an economic impact even on a sovereign or a company. Yeah.
So you've entered into these contracts. You have an expectation that you're going to be able to deliver in a certain way. Suddenly, you're not able to do that. You need to come up with these creative solutions on how to still be compliant.
There we go.
Yeah, there we go. So, you have an expectation of being able to perform now. You need to be able to address this. Trevor, from a legal advisor's perspective, how does it affect our ability to give our clients advice? Is it a really valid criticism? Yeah.
Johnny, there's no doubt that sanctions have complicated and often restricted access to justice and made advising international clients or South African clients with international reach more difficult and complicated. But I wouldn't go so far as to say that it's that sanctions an absolute bar to the rule of law being applied in relation to contracts that involve sanctions more broadly. So there's obviously there's a tension between applying the rule of law and the ultimate goals of sanctions, which, as you said, are theoretically for governments and international organizations like the UN to maintain international peace, security, prevent terrorism, and the influence of rogue states and rogue individuals. But I believe that tension can be managed by lawyers being aware of current limitations, being on top of available exemptions and grounds, licensing grounds, and generally being more flexible and creative in relation to the drafting of dispute resolution and force majeure clauses, and in that I include illegality clauses. But I mean, obviously, I readily concede that that's much easier for forward-looking contracts. It's far more difficult in relation to an existing contractual arrangement where sanctions have not been dealt with or foreseen. And also there's a difference between primary and secondary sanctions. I think advising clients in relation to primary sanctions is probably no less complicated, but there's more certainty, I think. Whereas, and I think this is where we deal with sanctions more and more, is in relation to secondary sanctions, there's probably less predictability as to what the correct course of action is. Also in relation to secondary sanctions, which, as I say, I think we deal with more often, there's less predictability regarding force majeure clauses. The other difficulty, I think, is that we're not privy or entitled to the same exclusion of liability provisions that in the EU, for example, if you are, you can perhaps touch on this, is that I think there if you follow sanctions, you're immediately indemnified for doing so, whereas in our jurisdiction, you don't have that immediate remedy available to you.
Neil, maybe you can come in here. So, from the perspective of a sanctioning state versus a sanctioned state and a sanctioned entity, do you have access to justice?
Well, let's start with sanctioning states, and Trevor mentioned some of the objectives of sanctions. I'd add another one is often, again from the perspective of the sanctioning state, to promote and uphold the rule of law. So again, from their perspective, sanctioning states would say that the effect of sanctions, which is often to curtail the property rights of individuals and entities, that's a legitimate means of achieving one of those objectives, being to promote the rule of law. Now, of course, that's a matter of perspective, and from the perspective of states that are subject to sanctions, the view is of course different, and we've seen one frequently discussed response of Russia, for example, to sanctions posed against it is the Lugovoy law, which was discussed in one of the sessions yesterday, and as many people will be aware, that's a provision which, in short, entitles the Russian courts to take jurisdiction over disputes involving Russian entities that are subject to sanctions, including when there may be an arbitration agreement that that would cover the dispute and would ordinarily refer that dispute to arbitration in a foreign seat, for example. And the presumption underlying responses such as the Lugovoy law is that sanctioned Russian entities, in this case, can't obtain justice in the sanctioning state. I would suggest that presumption in itself is not correct. It's certainly true that the sanctions are supposed to be draconian. If we look at the freezing sanctions imposed by the UK and the EU, or the equivalent blocking sanctions in the US, very broadly speaking, they prohibit almost all dealings with entities that are subject to the sanctions targets. And that's quite apart from the parallel freeze or block on assets located in the relevant jurisdiction. But I think as a broad generalization, at least, the sanctions aren't usually intended to prevent a sanctions target from accessing courts or tribunals. And certainly in my own jurisdiction, England, we have, for example, a Court of Appeal judgment from 3 years ago, Mints and National Bank Trust, that confirms that an English court, at least, can grant a money judgment actually in favour of a sanctioned party, a Russian sanctioned party, without in itself that constituting a breach of Russian sanctions. And then, so perhaps more concretely, when it comes to access to justice, again, looking at my own jurisdiction, the UK authority that administers financial sanctions, called the Office of Financial Sanctions Implementation, has issued a series of general licenses, really with the objective of ensuring that that sanctioned parties can access courts and tribunals, either seated in England or in England. And those general licenses permit, broadly speaking, sanctioned parties to make payments, for example, to arbitrators, to arbitral institutions, to law firms, in order to participate in arbitrations, for example. Those are all subject to various limits, but I think the broad principle behind those licenses, and it's repeated in other jurisdictions as well, is that, again, as a sort of a broad principle, sanctioned parties are permitted or should be permitted to have a claim or defense adjudicated in arbitration.
So we see that sanctions are actually just not a political issue. They have a very real effect in this context on our clients, on the way we practice law, and generally how we obtain access to justice, right? But then how do you actually resolve a dispute well? How do you deal with all of these kind of concerns, things like impartiality, uncertainty, a jurisdiction that feels safe? Now, instinctively, you want to say, okay, go to a neutral state. But is there such a thing in a world of secondary sanctions, where we in South Africa may be transacting in Europe and would need to comply with EU-related sanctions? So, is that really a neutral state? Trevor, any ideas on how we can go about ensuring that we resolve disputes effectively, efficiently, viably?
Yeah. Well, I mean, as we all know, we live in an extremely fluid world at the moment, and I think rather than trying to identify the best forum with reference to shifting foreign policy objectives, the better approach would be to look at the integrity and sophistication of a country's dispute resolution mechanism and institutions. And in that regard, and I think we all probably agree there, a dispute resolution system should guarantee and actively promote access to justice and in an array of fora, and then unapologetically defend and safeguard the independence and impartiality of institutions which provide access to justice, have well-defined checks and balances, and have the infrastructure to support substantive fairness in relation to those dispute resolution processes. And this is probably a shout out for the global South, but in South Africa, for example, and we're aware of the fact that our arbitration is protected and enshrined as a valid form of dispute resolution in our constitution. We have Section 34 of our constitution, which, although not directly applicable to arbitrations, I think there's arguments that you can get there, by interpreting the Bill of Rights. You have legislation. Obviously, we have the International Arbitration Act of 2017, and then you have, the common law cases like the Lufuno Mabapuli matter, the Industrious matter, which have all underscored the enforcement of arbitration agreements and the quick enforcement of arbitration agreements. So the ingredients are there, and I'm not saying that's the only jurisdiction by any, there's no doubt about that, but that's probably a better lens to look at things through, I believe.
So it's very easy to get lost in the political discourse. But if you kind of strip all of that away, you look at what are the ingredients for a good forum, right? And if you tick all of those boxes, or most of them, that could be a viable jurisdiction. Lele, with that in mind, is arbitration still the preferred dispute resolution mechanism in corporate commercial transactions?
Generally, yes. We prefer arbitration because of confidentiality. We deal with a lot of sensitive issues, when we do have disputes. We generally actually never start any disputes, for the record, but we find ourselves challenged. But in the context of, in relation to a sanctioned entity, it becomes a little bit difficult. And difficult in the sense that I gave the example of a vendor that would have had much difficulty with complying with sanctions frameworks. We wouldn't be trying to enforce a breach of agreement in that context. We terminate, and we have a termination for no reason. We get out, we find someone who can do this for us cheaper and better, hopefully, with less issues, right? But if that, let's say that particular vendor took us to arbitration, we would be very happy to use a arbitral forum to deal with that. We have seen that happening by individuals who have, complaints and wanted to take us to arbitration and happen to be sanctioned, or have challenges by virtue of them coming from sanctioned countries. It becomes impractical in the sense that, the ability to even access the arbitral forum becomes challenging without the general license, or without flexibility from the arbitral forum, because there has to be fees that they're paid. They have to pay lawyers. Trevor doesn't wake up for less than a certain amount a day. What can we say? And also now, even if you get the outcome that you're looking for, which is usually sounding in money, right? We have an instance where we won the arbitration with costs, right? But the people are in Iran. What are you going to do? I mean, who are you going to instruct to recover what? How are you going to get the money? What is the point, right? So you have this award, but does it really mean anything if you can't get the value that you're looking for? So those are kind of things that we have to think about when we're looking at arbitration and juxtaposing that with sanctions.
Okay, it's good to know that we still have jobs. So arbitration is still a valid form of dispute resolution. It certainly is in MTN's contracts. That's good to know. But Lele, it's exactly what you said. So arbitration can be preferred, but we can't ignore the fact that there are pressure points. Yeah. You need to make sure that, sanctions can undermine the efficacy, right, of an arbitration process. So what are those pressure points? You've mentioned some of them. Trevor, how do we actually address them? So enforcement, payment, and the like.
Well, I'm also glad to hear that the rationale for arbitration remains intact. But of course, you're right. The sanctions undermine the efficacy of arbitration, and if pressure points are not adequately addressed, there's a problem. So I previously alluded to the need for lawyers to become more flexible and creative in negotiating the pitfalls of sanctions, and as I've conceded, that's more easily said than done, and it's more easy in relation to forward-looking contracts. But it's, knowledge is power, and if we don't talk about these things, we will never be prepared. And I think key to this approach is abandoning a boilerplate approach to dispute resolution clauses, force majeure clauses, illegality clauses, all of those things. And potentially, and I said, because we don't always have the protections here in terms of the EU regime, looking at exclusions of liability because of non-performance due to, and it depends which party you're obviously acting for. And when I say creative, looking at alternative forms of performance, potentially, alternative payment structures, and even an arbitration clause itself could potentially have certain safety valves built into it. In the event that sanctions make it too difficult to enforce, there could potentially be a secondary dispute resolution mechanism that gets activated. And it goes back to the key ingredients for an international arbitration clause, the scope of the disputes that need to be referred to arbitration, providing for institutional ad hoc arbitration and the applicable rules, the applicable laws, including substantial governing law or the law of the seat, and interim measures and urgent relief. I mean, those are just the broad headings, but I think the person, when we say drafting something that's fit for purpose, it must truly be fit for purpose with sanctions and secondary sanctions in mind. And that means us actually potentially with our transactional lawyers sitting down and really thinking about the risks that lie ahead and then drafting appropriately.
It's a lot to have to think about. It strikes me that there's probably some need for institutional reform, some things that can be implemented, whether that's at legislation level or within arbitral institutions themselves, to kind of safeguard arbitration as an institution. Neil, what's happening in that realm? So what's underway? What still needs to be done? How far are we?
Yeah, so, I think one of the reasons why there's such complexity is that when it comes to sanctions is because sanctions are often coordinated amongst sanctioning states, but that doesn't necessarily mean that they're consistent amongst the different regimes. And that sort of multiplicity of different regimes becomes particularly challenging in international arbitration, just simply because of the number of different laws and jurisdictions that can sometimes be at play in international arbitration matters in particular. So, for example, you might have a law of the seat, which is different from the substantive law of the dispute, and that might give rise to difficult questions as to the interaction between the different sanctions regimes under those two jurisdictions. The nationality of arbitrators might be relevant because typically individuals must comply with the sanctions laws of their own jurisdiction of nationality, irrespective of where that person is, and so that includes arbitrators sitting in a hearing room somewhere else. And then also, just as another example, the sanctions law applicable to the physical location where a hearing might be taking place can also be relevant if, for example, it prevents witnesses from travelling to attend the hearing. So that's all a lot of examples of problems, and I lay that out because I think that it's probably wishful thinking to hope that there might be harmonization amongst all of these different sanctions regimes. And one of the key reasons for that is that the sanctions that we typically deal with at the moment, particularly, for example, the Russia sanctions, are unilateral sanctions implemented under sanctioning states' own autonomous sanctioning regimes, rather than pursuant to, for example, a UN Security Council resolution. And therefore, sort of almost by definition, they aren't harmonized amongst each other. And I think it's probably wishful thinking to hope that might happen. I think what we can hope for, and what is a realistic objective, is to hope and press for greater clarity in individual sanctions regimes as to what's permitted and how in terms of sanctioned parties participating in arbitrations, and also how arbitrations can be resolved where a sanctions issue arises as part of the arbitration. And I think that that's a matter for individual sanctioning states and their courts most often, but as new sanctions regimes stay in place for longer, I think there is a gradual process where that does take place. There is improving clarity. And just to take one example, in the UK there's a broad prohibition on lawyers providing non-contentious legal advice to Russian entities or matters connected with Russia. And in late 2024, we saw the legislation implementing Russian sanctions amended just to clarify that, and in particular, that introduced an amendment to a definition that made clear that that particular restriction didn't apply to advising on international arbitration matters in any jurisdiction. So I guess that's an example of how we can hope for improved legislative clarity in individual sanction regimes. I think the other thing to bear in mind as well is that, again, sticking with the Russia sanctions, those sanctions have been in place for over a decade, and they've certainly become more stringent since 2022. But the major arbitral institutions have a great deal of experience now in administering matters where there's a party that's subject to sanctions, particularly given the sheer volume of Russian-related disputes that have traditionally been referred to arbitration. And I think it's clear that the arbitral institutions, the major arbitral institutions, are very willing to administer arbitrations involving sanctioned parties and to make it work, obviously subject to the confines of the relevant sanctions legislation. But I think that is a positive step forward. Yeah.
Perhaps going back to Lele's point about the I call it the toothless tiger problem. Okay, you get your arbitral award, even in a sanctions adjacent kind of matter. You now need to be able to enforce it. There are a couple of pressure points there, right? You need a truly independent and impartial tribunal. So what does your tribunal look like? Neil, you mentioned some of the examples looking at the nationality of your tribunal. So none of your tribunal members can come from the sanctioned state or the sanctioning state. You could also look at creative ways of how to go about ensuring payment, yes, making sure that, you know, if there's a witness that can't travel to a country, how do you accommodate them? How do you make sure that they are able to give their evidence in a complete and clear way? How do we deal with enforcement? Trevor, maybe you can go first. What else have I not spoken about?
Yeah, well, I think we must, again, and this is standard for any looking forward to any international arbitration, but we need to look at the arbitration clause must be valid in terms of, and then you'll have to look at all these things, the substantive governing law, the law of seat, the law where the arbitral award will be made, the law where the parties are domiciled, and then the law where the favourable award might be enforced. You kind of have to cover all of those angles to make sure that the award is enforceable in all those different jurisdictions. No easy task, but unless you're thinking about that, you are going to come unstuck, and you're not going to, at the last hurdle, you might not be able to enforce, as Lele's example. But if you know that in advance, then corporates can understand what risk they're taking in procuring these kinds of services or entering into this kind of transaction.
So it's about front-loading
Yeah.
the negotiation of your dispute resolution clause. And yes, that sounds very commonsensical. I mean, you're going to put it in a transaction agreement, of course. But often our transactional lawyers might not be actually consulting with us, and we probably need to make sure that we're in that office and part of those negotiations. Clients will probably have to indicate to us what the pressure points are, where could enforcement potentially occur. Neil, what about what we're seeing at the moment with, you talked about Lugovi's law, where we are seeing parallel arbitration proceedings, and then we've got, at the same time, proceedings in a Russian court. Perhaps you get your judgment in a Russian court sooner. So how do we go about ensuring that an arbitration agreement can still be enforced fairly? I'm thinking, we need to look at the New York Convention. That's probably a good starting point. Any other ideas?
Well, I mean, yeah, you mentioned the Lugavoy law and the fact that that's given rise to litigation in many jurisdictions, particularly around various parties seeking anti-suit injunctions or anti-suit injunctions from various state courts. I suppose that's kind of a stage down the road where one party has failed to comply with the arbitration agreement, and so I suppose ideally you don't want to get to that step, and you want to be at a stage where both parties are reverting to arbitration in accordance with what they think their agreement is. As to whether what you should do to try and avoid that happening in the first place, well, I suppose as parties are contracting now on a very much forward-looking basis, then yes, there are considerations that you can build into the arbitration agreement in order to perhaps try to foresee the impact of any new sanctions that might come in the future. And I think the others have already alluded to some of the things that parties can think about. So, for example, choosing a seat that, whether that's in South Africa or in one of the Asian jurisdictions. Now, seat choice in itself doesn't entirely insulate a contract from the effect of sanctions, and ultimately, if one of the parties or the subject matter of the contract or the proper law of the contract engages sanctions issues, then that's going to be relevant to an arbitration, kind of irrespective of how you try and draft around it. And I think at that stage it becomes important to think about some of the contractual protections that you build in elsewhere in the contract that Lily's mentioned. So, for example, having a right to suspend performance if it's affected by sanctions.
I think this is a good point for you to come in. Okay, so we're talking about things rather academically, but you can be a really good lawyer and a really good technical lawyer, but we may have blind spots. I think all lawyers do. What do you want us to be thinking about when we're advising you? Is there something we are missing?
I think the starting point is a company like MTN goes into a market to provide a service, and in doing so, wants to do it in the right way, in compliance with the law. So you would generally choose a country, a vendor, an onboarding process that supports that, even for your customers, looking at the different services that you have. But there will be a tension between local laws and the international standards that you're looking to apply, whether it is sanctions or GDPR or whatever, right? And a lot of the times, I mean, an example will be a customer is in market X, has a SIM card, has a Momo wallet, transacts, everything is perfectly fine. They get listed on the SDN list, and we say to the person, so sorry, we're going to have to suspend your number and financial services because, you might take us into the realm of money laundering and all of that stuff. That sounds great for us from a multinational's perspective, but they go to the courts and the courts say, well, we don't really recognize that sanctions framework. Why do you think that trumps this person's rights, right? Or a simple thing, a shareholder dispute, ordinarily is perfectly fine, but you go to the local courts for them to enforce maybe an arbitral ruling, and they take a dim view on those kinds of things, or in some instance, the minority will front-run the process by going to the local courts to frustrate what would be the international arbitration. So when we're drafting these contracts, we need to also bear in mind that whilst sanctions frameworks from an EU, US, UK perspective are there to really deal with, from a policy perspective, rogue elements, they have a political dimension that would play out locally because it would not be interpreted in the context of what it is intended for. And so the advice needs to, I guess, be practical in the sense that, yes, the arbitral clauses are great, international arbitration is great, and generally we prefer that standard, but we still have to come back and localize it and across different markets. I mean, from an MTN perspective, it's much easier to apply these frameworks in common law markets, although in some instances we do have some struggles because of the political complexities that are overlaid by these sanctions frameworks. But then you also have to remember we have Sharia law markets, we have OHADA law markets, and it's just a cocktail of complexity that we have to try and unravel and simplify so that it doesn't affect how we do business.
So a good lawyer is giving you contextually informed advice. So we need to know your business. We need to know where you're operating. We need to know what that legal landscape looks like, but what are the difficulties you're dealing with on the ground. So we can draft a really, really good clause, but can we apply it in context?
And also we need to make sure that our businesses across the board understand the broader context. I mean, if you go to a country and you say, well, I mean, we can't offer these services to these 15 people because they are on an SDN list in the US, and they say, well, we don't have any dealings with the US. The only relevance is because you have a investor base from a US perspective and loans and stuff like that. That has got nothing to do with us here locally, right? And you can understand the context of the local market, but they need to have a perspective of, from a multinational perspective, that is how contagion risk starts, right? So how do you need to understand our business, but you need to also be able to help us incorporate the local perspective there and help us cauterize the problem as much as possible without amputating anything. And also just make sure that, operationally we still remain effective. Yeah.
Okay, I'm not sure we can be doctors and lawyers, but we'll do our best. Yes, I think a nice rule of thumb is be creative within the box of the law, I suppose. Be agile. There's no use sticking to a very rigid sort of worldview or advice that isn't kind of evolving over time and responding in real time. Thanks, Lele. That's really, really helpful. No, not difficult at all.
I think we can mitigate those risks.
We'll do our
As you
best.
say, we're not doctors. We can't insulate you completely from
We
those
don't
risks.
have any cures up our sleeves, but we'll do our best. Thanks to the panelists. We actually do have a little bit of time for some questions. Let me check. We've got about 5 minutes. Is there anything from the audience? You might need to come and grab a mic. Just need to switch it on.
Hello. Okay. Thank you, all the panelists. The one kind of, I wouldn't say it's terribly creative, but talking about front-loading kind of risk, just the option of maybe taking security at the beginning of a dispute, mechanisms that arbitral institutions give for that. I was wondering if anyone has maybe experienced that, if it's been successful, because then I guess you could put funds aside in perhaps a bank account that isn't attached to a sanctioned jurisdiction, so that if costs are awarded or award is given, that the party that obviously is successful might be able to have access to those funds without too many obstacles. Any perspectives?
I think that, yeah, I mean, that's, depending on the bargaining position, of course, you could build that in, but once a dispute emerges, it's very unlikely that you might achieve that. I mean, I think once positions harden, and if one party thinks that they may escape a damages claim, for example, they're not going to put up security. So,
I think, so I have experience of dealing with something that's similar in a sanctions context. And my own experience is that you can try to do that if the parties will agree at a pre-contractual stage, but often if it's affected by sanctions, the sanctions will probably stop you from enforcing the security in one way or another. No matter how creative you might be about trying to foresee how the future sanctions might sort of come in and how you might be able to work around it. So,
And that's probably because they're drafted so broadly, right? Some of the US sanctions will say directly or indirectly facilitate XYZ. Some other sanctions regimes are a lot more kind of limited. You can't use the money to buy arms, so to speak. So perhaps in that case, if you've got a performance guarantee that's built in a bit of a buffer in case a dispute were to come up, depending on the jurisdiction, potentially, I suppose, you could draw on that bond of some sort to pay arbitrators, to pay legal fees, etc. But I have personally never seen it done. We should talk to our transactional lawyers on that one.
Yeah, just to add, even if there was a requirement, I mean, there's a security for the proceedings themselves, but the outcome of that can't be predetermined, right? One party either wins or loses, or somewhere in the middle. If, for example, we were in an arbitration with a sanctioned individual that has the right to enforce their rights, of course, and we lost because we didn't do the right thing or we terminated their contract, and we had to pay them, and the ruling was against us, I can assure you we're not going to pay. They would have to go to the highest court in all the lands before we pay, and we would drag it out until the sanctions get lifted. So it's just one of those things. That's the flip side of it. I mean, because that would mean a corporate is providing material support to a sanctioned individual. It just can't happen.
Lele doesn't want MTN to end up on a sanctions list.
there's one at the back.
Thank you, Kirsten.
Thank you very much to all the panelists. You did share on the importance of probably having innovative ways of ensuring that you do get paid. May you share examples of some of those creative and innovative ways, which are practical for us as practitioners to take away and to be able to incorporate even in the arbitration agreements that we will be drafting. Thank you very much.
Bitcoin, okay, I joke. Bitcoin is actually subject to some sanctions nowadays. So we spoke to some of it, right? There are derogations that can be put in place. So as a legal firm, you can apply to your relevant anti-money laundering body. You can get a license to unfreeze certain portions of funds that are sitting in a bank account. You need to be proactive with that kind of stuff. It needs to be, the license conditions also need to be quite robust. I think there's a tendency, at least in Europe, they get sort of these once-off derogations if they don't have a kind of license. Something we were thinking about, Trevor, and we actually don't have the answer to it. Could a South African law firm avail itself of derogations through, say, one of our correspondent firms sitting in Germany? Could we get paid, that way? And really, it's all in the drafting of those licenses, of those applications, and putting together a really good case. So you don't get these licenses or these derogations just very easily. You have to show that you're compliant in every other way. You have to show where that money is actually going to be sitting for a little bit, who's going to get the benefit of that interest, what portion is being unfrozen. So I think it's about really applying your mind to what you need the money for, from where, and where it's going.
Maybe just, Neil, I mean, I know that there are general derogations, and then there are also ad hoc derogations. I mean, in the EU, just your thoughts. I mean, if we were doing a matter in South Africa and there was a sanctioned party involved, do you think we would be able to access those derogations, being a non-EU country?
Well, perhaps I should speak about the UK, which is probably where I know more about. And the answer is, as a general proposition, yes, anyone can. When we talk about general licenses, anyone can avail themselves of it. I mean, I think one of the issues that comes up with payment flows pursuant to a license is that just because it's lawful doesn't necessarily mean that all the banks that need to be involved in the payment flow will necessarily pass the payment through, because there may be an issue of over-compliance, or many banks are understandably nervous about having to rely on a license and the possible consequences if they interpret it wrong. So there's certainly a practical difficulty around making payments, particularly to law firms. I mean, anecdotally, I'm aware that when I've acted against sanctioned parties, I'm aware that some sanctioned parties have been able to make payments, for example, for hearing venues, by making the payment through a law firm, and that's talking about a payment that's lawful. So it's not an attempt to circumvent sanctions, but it's simply making a payment through a law firm that isn't in itself on a sanctions list. And anecdotally, I understand that's one way that counterparties have been able to make payments in order to participate in arbitrations.
But also, I think there's the legal parameters, and then there's the reputational blowback. And I think a lot of banks, law firms, just won't go there. They won't take the reputational risks. So that's a different layer of complexity.
Yeah.
Perhaps one more?
Thank you. I just had a question about enforcement. Do you think, assuming this issue wasn't raised in the arbitration proper, that when it comes time to enforce, the New York Convention provides that an arbitration award must be recognized and enforced unless one of the grounds exists not to, and one of those is public policy? Do you think it would be a persuasive argument that if you recognize and enforce this award, it will cause me to have to breach sanctions by making payment to a sanctioned party, therefore it's against public policy to recognize and enforce this award? Do you think that would be a persuasive argument, or do you think a court would say, there was a comment yesterday that the public policy component only applies to the enforcement, not to the merits of the dispute? So I'm just interested to get your take. I don't think there's an easy answer.
Well, I think in the EU, I think there's the Bondi opinion, which says that the EU sanction regime is part of public policy. It's not a binding, it's just an opinion as I understand it. But if that logic's adopted, then I think there are a whole lot of raft of other problems that emerge in the enforcement at the enforcement stage. So it becomes a bit of a circular debate, and I don't know if you've got any practical.
I mean, I think the answer is it depends, but maybe. And there's been a number of cases in England that have tried arguments along these lines. One a few years ago that was successfully used as a means of avoiding enforcement, specifically in relation to interest that was accruing on an award. But on the other hand, literally a few days ago, there was a judgment in England where an attempt to rely on public policy on sanctions grounds to resist enforcement was rejected. And I think, broadly speaking, certainly speaking about England, the courts, when it comes to enforcement, are fairly wary of parties trying to use sanctions as a sort of get-out-of-jail-free card to avoid enforcement, and those types of arguments are looked at pretty critically and fairly narrowly. But in principle, yes, I think it's a possible defence to enforcement.
Been decided in South Africa just yet, but all over the world, public policy has been interpreted to avoid complying with an arbitral award, but equally been interpreted as having to comply with an arbitral award and international law and legal norms. So I think it is, unfortunately, very much a circumstances of the case position. Yeah. Good. Thank you so much, everybody. That was fun.
Thank you.
Good.
Thanks for coming all the way from.
Oh, pleasure.
Sweet. Lily, thank you.
Thank you.
Thank you. I think our mic's still on.
Oh, okay.
Mine is.
So do you think that sanctions are still in place, or they're just a suggestion?
Advisory,
Hi, how are you?
guidance. Yeah.
All right. Hello, everyone. Can you believe it? We've come to the end of our sessions for today. And our final session in this breakaway room is titled Critical Minerals, Energy Security and Strategic Supply Chains Disputes in the New Geopolitical Background. In this session, they're going to be examining how resource competition is reshaping global dispute dynamics as demand intensifies and supply chains become more contested. Arbitration is increasingly central to navigating risk, securing investment, and of course, resolving cross-border tensions. To help lead this conversation, I'm going to welcome to the stage our moderator, who is director at CDH, Denise Durand. Also, our panelists are Clive Rumsey, Jack Walferris, Vivian Chaplin, as well as Burton Mayer. Please give them a very warm round of applause.
I'm a bit short. Okay. All right. Afternoon, everyone. Thanks for choosing our session. My name is Denise Durand, as the MC said. Yeah, I think we don't have a time thing. Okay. We'll have to play it by ear. As she said, the session will be unpacking critical minerals, energy security, and strategic supply chains. Thank you. Thanks. Appreciate it. Thanks. And to ground our discussion, I'll offer a few brief opening remarks. We're all familiar with the global transition underway, driven by a rapid advancement in technology, the race to strengthen military capabilities, and the urgent shift towards cleaner, more sustainable energy systems. At the center of this transition is a sharp rise in the demand for specific minerals, cobalt, copper, manganese, rare earths, amongst others. With such a high concentration of these resources, the continent is well positioned to supply them. This is not the first time Africa has found itself in the center of a global resource competition. The historical parallels are hard to ignore. The difference, though, today lies in the objectives, and it is within this shift that tensions around supply chains emerge. On the one hand, countries are seeking deeper trade integration, as reflected in the AFCFTA. On the other hand, countries are under increasing pressure to safeguard domestic interests. This is driving policy shifts towards beneficiation, export restrictions, and for lack of a better term, resource nationalization. For investors and supply chain partners, this creates uncertainty, compounded by infrastructure gaps and limited industrial capacity. And where there's tension, disputes are not far behind. Session 4 yesterday gave us the architecture, the BRICS realignment, the AFCFTA promise, and the fading rules-based order. Today in our session, what we will do in our session today is to see how that then lands in a contract, in a mining license, or an arbitration clause. And Jackal sits at the intersection of all of these, so I'll bring you in first. What is the single most important thing about why our critical minerals have now become issues of energy security and national survival and not just trade?
Thank you. Thank you, Denise, for the question. And you must probably also apologize to the audience that you're here at this time of the day. So apologies. Hopefully you're still awake and ready to absorb some information. But as Denise said, so yesterday we spoke about the fragmentation in the global order, and we unpacked, for those of you who managed to attend, we unpacked what that fragmentation means and what it factually is currently within the context of the global south, BRICS, and also what is happening on the African continent from an AFCFTA perspective. So we have two forces that are pushing essentially against each other in various ways. That's why we're talking about the West, as we know it, and from a rules-based system, that system is fundamentally changing as a consequence of what is happening geopolitically. And our topic is disputes in the new geopolitical battlegrounds. So one of the battlegrounds that we would see, and if you just pick up a newspaper, you would read about critical minerals and the importance of critical minerals. So for those of you, either you are aware, and I'm not saying that you're not aware of what the critical mineral is. Actually, critical minerals in essence are minerals classified by, and each state would have their own definition of why they consider a particular mineral as critical. I think there's about 60 minerals that are considered critical, and on the African continent, there are several of those who are deemed, either the US has a specific classification of what is critical, China would have a specific classification of what is critical, and also from an African perspective, even South African published our own strategy of what is critical minerals. Now, the battleground is, so from a US Western perspective is, the critical minerals are required for high-tech equipment, for batteries, for the transition. So your EVs, renewable, your wind turbines, semiconductors, missiles, all of those things. So they are, and that's why they're called critical, because they are required in the new generation of what the technology and industry is. So on the one hand, you have the developed world that needs that for specific requirements and their needs, and you also have Africa, where a lot of the critical minerals are mined, processed, but not necessarily refined on the continent, and those are exported. And last year, during the G20, and we will discuss it in a bit more detail, during the G20 summit, there was a declaration that was adopted by all the G20 countries, bar 4, as we know it, the US didn't attend it, and the US this year had another summit with certain select countries. So in that G20 declaration, what it contemplates is that from an African perspective, seeing that we had a summit on the first time on the African continent, is that there is an imperative that there should be refinement and beneficiation of minerals on the African continent. So whether it's lithium, whether it's cobalt, whether it's any of the other critical minerals or rare earths, there needs to be value addition, and then it's exported either to China and so on. But then on the other hand, we also have the Chinese. So the Chinese actually probably refines the most critical minerals. So if you export it, it's refined there. You would have heard yesterday also the Chinese government, through agreements through the South African government and the Chinese government and other African states, introduce free tariffs. But what does it actually mean also? So you have this tug of war. Are we only exporting raw materials? But then it goes against the fundamentals of beneficiation. And that's the fundamental purpose of the AFCFTA also. So AFCFTA is to encourage the actual production and value addition on the continent. That's the fundamentals. Now, you have the tug of war between, are we serving the West, are we serving the East, or are we serving ourselves? Our own blueprint, which is the AFCFTA, says we need to serve our own interests. But we also need the capital, and some of my colleagues like Vivian will talk about the financial implications. So you have this divergence of there's the established West, the Bretton Woods institutions, you have the East and the BRICS, but you also have a fundamental African interest saying we cannot continue to be left behind by serving the interest of everyone else and not people on the African continent. We're not going to achieve the laudable objectives in the AFCFTA to say we're going to create value on the continent if we just continue to export these minerals. So critical minerals is seen as the next gate for Africa to be a catalyst for economic development, because energy transition is real, whether it's through green hydrogen, whether it's renewables, and any of those transitional fuels, it is a reality, and Africa can't be left behind. But the question is, in this context of a fragmented global order, how do we play this out? Because we have to, as a continent, also balance interests between the East and the West and our own interests, because we need capital. And capital needs to be protected, and there's various risk considerations in terms of that. And we'll discuss that probably further as part of our session. Thank you.
Thanks, Jacob.
Denise.
And I think to show an example of this grapple or this grappling that the states have, I mean, in Guinea last year, the state revoked quite a few mining licenses. Well, most of its mining licenses from the major foreign producer. And as we know, bauxite, and we know that bauxite is instrumental with aluminium, so you think solar panels, wind turbines, and EVs. So that's an example, and when a state does something like that, right, where should it invest in a critical minerals project focus its protection first? So, you know, the contract, the investment treaty, or political alignment?
Thank you. I think that's a very fundamental question, as a firm, and again, my colleagues will also unpack this. This is what we also do on a regular basis. So the risk doesn't start when the government, at a particular point in time, decides that they're going to revoke, whether there's a legitimate reason for revoking a license or not. See, that's assessment on the merits. But before you enter a market, and this is one of the things we also, there's a risk assessment that needs to be done prior to the time. So there's an element of the BITs. So before an investment is made or is done, in particular in sectors that are prone to what we will call political risk, any multinational that has done this would do what we call a political risk analysis and assessment of a particular jurisdiction in respect of their government and so on. Because you have to accept, from a political perspective, whether you invest in South Africa or Botswana or the DRC, there will be changes in government. So every 5 years there's changes in government, every 10 years there's changes in government, but obviously there's a legal system also that governs it. It can also change. So the first thing is you would do a risk assessment, and part of the risk assessment for us would be, is there a valid and enforceable BIT or any other what we call multilateral investment agreement? And the reason for that is, yes, there's a number of guarantees that you get in these things against expropriation, fair and equitable treatment, free transfer of capital, and so on. But fundamentally, and this is a conference about dispute settlement, is you need to ensure that when that dispute, so 20 years from when you concluded the contract, you need to already anticipate that there will be a dispute, potentially. So is there an effective dispute settlement mechanism? And typically we look at the exit, is there investor-state arbitration mechanisms, and so on. So in that example, and I think that example is a good example, there's a BIT between the UAE and Guinea. And under that BIT, the UAE national initiated an arbitration against Guinea as a consequence of the decision. Again, we're not going into the merit, maybe the government had good reasons to do so, but the protection is you would not want to subject yourself as an investor to the domestic dispute settlement system of the state, because I'm investing $1 billion or $2 billion. It's a long-term capital investment. And one of the key principles also in this is, there's a principle in economics called the captive nature of investment. So in the beginning, governments will court you, and they will say how great they are and how great their policies are, and we have all of these things. You then make the investment. Your investment is there. You can't move your mine. You can't move your refinery. You can't, it's there, it's captive, and that's why we call it a captive investment. So if you didn't do all of those assessments and government changes, then the risk flows, you now need to initiate a dispute settlement. So investment structuring is important, your dispute settlement clause is important, and how you enforce it. And again, not going into the merits of how those things are ultimately determined. Thanks, Denise.
Thanks, Jaco. And you've already touched on this a bit. So we've had a couple of developments, right? I think you'd mentioned the G20 Johannesburg Summit and the endorsed beneficiation. Then the US extended AGOA. South Africa, and a few days later, South Africa signed a framework deal with China targeting duty-free access for its mining exports. And then we still have the AFCFTA investment protocol that is still not yet in force. So in these three things, I mean, can they coexist? Or is Africa being pulled in directions its legal architecture is not yet equipped to manage?
It's a difficult question to answer, but I think from an African perspective, the coexistence has to be, again, within the context of what we see as the blueprint for Africa, for Africa's development, because we're talking about investment in trade and sustainable development, where we need to, there need to be, and this is the AU's words, which is on behalf of all the other African states, is we need to literally get 60 to 100 million people out of poverty or into the middle class. And then you have the tug of war between two systems, and some of them, I think we lean more so to the global south in respect of our developmental agenda and I think policy. But again, from a financial capital markets perspective, you get most of your funding still today from Western institutions, but that is changing. But again, so AFCFTA is the key to where we are going. And that means we need to ensure that, having regard to this tug of war, we still ensure that the fundamental principles in terms of development is achieved through those instruments. And one of them is, you touched on the investment protocol. So the investment protocol, and we speak about all of these laudable things about trade and investment and so on, but the reality of the matter on the content is that if we cannot get a product from the DRC to Durban or to one of the ports at a least cost basis, then it becomes uneconomical. So you first have to invest in infrastructure. And infrastructure, according to the African Development Bank and the World Bank, there's about $100 billion in deficits on the African continent in trade-related infrastructure. So that's roads, that's ports, and again, Vivian will speak a lot on that, railway. So we need to get the ore to the market. So we first have to look at all of that. So invest in infrastructure, yes, serving of the Chinese market, but also balancing all of those things with the African need to ensure, invest in infrastructure so that we can beneficiate the products at low cost, and that means investing in proper and efficient energy infrastructure that either runs on gas as a transitional fuel or on nuclear or renewables to get it to the market. But to do that, and the fundamental point here is people are not going to invest billions without protection. Protection is significant, legal protection is significant. It comes back to, where do I resolve my dispute? The investment protocol gives all of these guarantees. So it's a document, it's been adopted by the majority of the African states as part of the AFCFTA. So it gives the protection on expropriation, FET, FET means fair and equitable treatment principles, on free transfer of capital. But the biggest lacking part of that is, again, dispute settlement. So it's been adopted, it's not gone through all the constitutional processes, and there's negotiation on the annex to that, which is the annex deals with how do we resolve disputes. And this is not this is for the benefit of investors, whether it's a South African investor or Namibian investor or a Kenyan investor investing, say, in Ghana to set up a manufacturing facility for whatever, for refining of some critical minerals. That investor is not going to put in the money if he doesn't have the guarantees. And one of the guarantees, you can give me all of these wonderful terms of free and equitable, I guarantee you I won't expropriate you if I do X, Y, and Z, if there's not an effective dispute settlement system. And the problem on the continent today is for 3 years, the annex has been negotiated. And our own country is also a problem because although South Africa is one of the biggest investors on the continent, our position, which is a public position, is that we are anti-arbitration and we want to mediate. And the question to the government is, but how can you say that? Because the South African investor would want to have certainty. If I invest in the DRC and there's a dispute with the DRC government, I wouldn't want to resolve my dispute in the DRC or by mediation. I want an effective and enforceable award against the state in respect of my investment following the principles. So those are the issues we are also facing on a continental perspective in respect of the AFCFTA and what type of dispute settlement mechanism we're going to use to resolve those type of significant disputes. Thanks.
Thanks, Jacko. I'll move on to Viv. I mean, Jacko has given us that macro picture, and we will dive into the sector itself with you. So we have export bans, in the DRC when it comes to cobalt, and recently in Zimbabwe when it comes to lithium. And these are no longer isolated events. How are export controls, quotas, and price interventions reshaping commercial agreements? And I suppose then the long-term project bankability.
Thanks. Sorry. Is that working? No. Is that working?
I don't think so.
Wait, that's working. Hi, everyone. I'm Vivian. I head up the mining sector at CDH. I'm a corporate lawyer, and I try to avoid disputes at all costs. So I'm in a very sort of unfamiliar environment today. But I think we all sort of going in the same direction, which is really how do we ensure that in this race for critical minerals and in the current environment, Africa gets a proper seat at the table and is not just seen as a supplier, but actually seen as a participant in the supply chain. And I think that's probably been a bit of a theme of the conference up to now. And obviously the AFCTA is very much geared towards that. So, Denise, in response to your question about export controls, quotas, and price interventions, I think they must be seen as sort of commercial levers as part of, and part of the vast range of tools that countries both in Africa and globally use in order to promote resource nationalism, which I don't actually love as a word because it's a completely normal commercial imperative and principle for countries to follow when they want to protect the resources that they themselves have in the ground and allow the people in their countries to benefit from the exploitation of those resources. So on the one hand, you've got the commercial levers of export controls, quotas, and interventions, and on the other hand, you've got things like equity participation, free carries of government, local ownership, local beneficiation requirements, and that forms part of the vast range of tools that countries have at their disposal. I think what we've seen in the last couple of years is that that some of these commercial levers have become the policy norm, and there must be, I think there's a kind of a spectrum of different commercial imperatives that can be put in place, from the bans right the way through to
to quotas and interventions. And I think you spoke about the DRC, and I think that's a very good example, because it started off with a ban on cobalt exports, and it's now graduated into a quota system, which I do understand is working quite well. So we can't look at all of these things with this we can't sort of paint them all with the same brush. It is a continuum and there is an evolution. But certainly, I think investors need to be very, very aware that, that these commercial imperatives are changing and can be enforced. So when planning an investment, I think investors need to take into account that whatever project plan they have has to have the right amount of flexibility to cater for changes, which are hopefully not too drastic regulatory changes, but changes that can be adapted for. So similarly, bankability has shifted completely, because I think regulatory risk is now kind of on permanent high alert. So both when evaluating a project and throughout the project, there's continuous evaluation of regulatory issues and the effect that could have on pricing. And that is a fundamental difference to I think, how mining projects were priced previously, which was a cyclical commodity price, driven by global factors. I think now pricing for investments is very much driven by geopolitics and political risk. Secondly, I think from a bankability perspective, infrastructure contribution and participation will be a part of any investment. So you no longer build a mine, you are going to build a power plant, you are going to build roads, you are going to build railway sidings, you are going to obviously do your community development infrastructure spend. So that also is very much part of the investment landscape. The next one would also be, from a bankability perspective, you would look at your contracts quite differently to the way we did previously. So your pricing clauses, your force majeure, your change in law, your hardship clauses have all gained a lot more importance than they had previously, because we know they're going to be triggered. And we can see that with the big amount of disputes happening globally. I think the one thing that we also need to understand is that whilst this resource nationalism is happening on the one end, on the other end, Western governments and Asian governments are responding with their own policies on their investments in Africa. So, for example, the new Trump administration funding frameworks and the US-Australia critical minerals framework includes commitments to pricing floors. So now we've got these competing interests on both sides, from the African countries and those that are partnering up with them. Obviously, tariffs, we're all trying to keep up with those. The US tariffs on steel particularly are really flying in the face of what Africa is trying to do by producing, downstream beneficiated minerals. So that is another curveball that we're trying to deal with. We've seen examples globally as well of other countries that have been challenged by the World Trade Organization, for example, Indonesia with their nickel ban. So there's a lot of change happening in the sector, and I think whilst we can see there is an evolution in Africa, and we think it's starting to work, we have to be very, very careful as a continent not to overdo it, and not for governments not to pull those commercial levers, too harshly, I think, to disincentivize investment. So in short, we've gone from commodity pricing to geopolitical pricing. Everything has to be structured with a lot more flexibility, and we have to try and ensure that as a continent we still present a good enough risk profile for people to invest.
Thanks, Viv. I'm just trying to be mindful of time. Not blaming you. As you were speaking, and this is a bit of an overlap, so Malawi has recently also suspended, their mining license, issuing of new mining licenses, as well as just the trade or, the export of raw and processed minerals. And you can comment more on, maybe don't comment more on that. But my question is, where's the greatest tension today between regulatory objectives and commercial realities downstream?
I think one of the big issues that we're facing is the fact that the actual factual infrastructure and skills on the ground are not matching the policies that are being put in place. So it is all very well for you to say, well, I want local beneficiation, I want refineries to be built when you don't have reliable power, when you want local participation or government participation and sophisticated projects where you don't have the skills or the political will or a sound political structure to support it. So I think there's a mismatch sometimes between the policies that are put in place and the actual ability to implement those policies. And I think that is also, something that we have seen become a real problem. And South Africa is obviously a bit of a microcosm for that, because with our very sophisticated and unique empowerment legislation, the mining charter, we really have tried to put something in place to get the change in political power to be reflected in economic power, but we've seen that there have been some, quite inadequate sort of enforcement of those policies, with corruption for BEE investment, and an inability to have the adequate power supply to keep our smelters going, to support our mining industry. So I think the biggest issue is this mismatch between the policy and the facts on the ground.
All right, and just to quickly segue into, just before we segue into Clive's section, and I think Clive might touch on this a bit more, but will regional corridors genuinely enable shared beneficiation and downstream processing while they're becoming new geopolitical choke points in the value chain?
So obviously, the corridors and the logistics challenges in Africa have been a huge impediment to us being able to really take advantage of this basket of minerals that we sit on. So I think the answer is really both. I mean, we do need to free up these corridors, and we can see that there's a lot happening. We can see like the Lobito corridor, where the US is pouring investment into. We can see the Chinese Belt and Road approach, which has obviously borne a lot of fruit for them in Africa. More recently on the Tazara line, which joins Tanzania and Zambia. So those corridors are freeing up, and they are critical. And then obviously there are other developments locally that we have in South Africa with rail privatization and the Luxembourg Protocol, of which we're an early adopter. So absolutely critical for us to free up the corridors and get our goods to the ports and get them exported from the ports. At the same time, we don't really want to just be repeating the same mistakes just now through the corridors. And I think that, as we've seen with the current war in Iran, these corridors become like such vital strategic points in conflicts, and become like a vital place where big superpowers can play games with each other. And I think that the US and China are sort of competing in Africa through those corridors. And we want to make sure, I think, as a continent, that that there are commitments and there's proper participation by local countries, and it doesn't just become a playground by proxy for other global superpowers to try and outdo each other and outmaneuver each other.
All right, thanks, Viv. Clive, I'll move on to you. So Vivian has told us where the pressure sits in the value chain. And when that pressure produces a project that's in trouble, what actually goes wrong? So we know that Africa is trying to move from a producing critical minerals position to a position where we process them. And that requires infrastructure, industrial capacity, and often that doesn't exist. So we read about projects, across the continent that are delayed or disputed or never completed. And my question then to you is why? So is it the contracts? Is it the parties? Is it the environment in which those contracts have to operate?
Thanks, Denise, and good afternoon, everybody. I head up the construction engineering sector at CDH. So we've heard lots of positive things about legislation, everybody wanting to do things and grow and develop. And we have a continent with massive potential and massive opportunities. But once and time again, we're getting projects that are not starting. And I'll go through some of the reasons why they don't start. And then when those contracts do get started, the problems that arise, and common problems that on the African continent we see from our own exposure and from those that write on the topic. Everything we've said this afternoon relates to construction, essentially. We've got to build roads, rail. We want to get stuff to port, increase your ports. We want to have a situation that we have fuel storage facilities built in various jurisdictions, and that's become all that more focused with what's happened in the Middle East. There's various countries at the moment in the SADC region who are building large oil storage depots to make sure that if they have any problems, that they've got those reserves in place. But the problems that we experience can be both geopolitical and economic. The geopolitical leadership can change in a country. We had an experience, we were involved in various projects in 2022, 2023, and 2024 in various sub-Saharan African countries that were having elections. A lot of money was spent, a lot of contracts were entered into. But when that particular leadership didn't win the election, those contracts were all put on hold. So they just came to an abrupt halt, and the new government is saying, I need to investigate every single one of those contracts, why they were issued, whether they were necessary, and the finance and to who they've been issued. So projects that were necessary in those jurisdictions ground to a halt. The other thing that you find in Africa is that people don't follow the process, the statutory procurement process. Time and time again, projects are held up quite simply because the parties don't follow the process. Contracts get awarded to entities that shouldn't get awarded contracts, and I'm not going to go into reasons and background as to why that might happen. But the problem with that is court challenges. And what happens with that? Delays. We've seen it in South Africa time and time again. Major projects, we looked at Durban Port, vital. What happened? When the first went out for expansion of the port, a company was set up 2 days before putting in the tender, who had no credibility, against a consortium of other contractors, and it got awarded to the new company that had no traction at all. When the ports and the management of the port was to take over, there was a challenge to that award to the Filipino company. So procurement, not following that process. If we put aside the geopolitical issues, and you look at all the stress points that have been mentioned of just doing business in Africa, and there are opportunities, but there are risks. And if we take away geopolitical leadership and what the politicians might do or don't do, it comes down to a lot of projects get delayed, there's claims, and there's disputes, and why? Most of the issues are issues which are within the control of the parties to that agreement. What happens, and why do they go wrong? Time and time again, you get projects where designs aren't completed. Designs are incorrect. The program hasn't been planned properly. Timelines that are just totally unsuitable. Planning that hasn't been done. Teams put in place to manage those projects that aren't yet put in place or don't have the requisite skills to manage those projects. And the projects go out to tender and the projects start. And no wonder they run into problems because they're not managed properly. Nobody's ever going to meet that time frame in which that project should have been finished, even if it ran totally smoothly. And owners and governments will sit back and say, I need to change something. And the contractors, correctly so, will sit back and say, that's fine. That's going to take you another 6 months and it's going to cost you another $1 million. And they say, well, that's unfair. We'll say, plan your project properly up front. Make sure your design is final before you go into doing a project. And these are the types of issues that are common in African contracts. They're common around the world as well. But in the African continent, research shows those are the types of issues that are becoming major problems, have been for some time, and will continue to be. So how do you solve that? You've got to make sure that the management of those projects, both from an owner perspective, a government or owner, and from a contractor perspective, you've got the right teams available to make sure that the work is done to the quality, done within the time frame that is a reasonable time frame, and to try and make sure that it stays at that budget that was intended. And there's various mechanisms to do so. And the shift of risk, the shift of risk used to be push everything to the EPC contractor. This is it, we want it done for this price within this period of time at this quality, and then the old adage, hand over the keys. And I have my refinery done, I have my hydroelectric scheme done, I have my fuel storage, and just hand the keys to me and everything's fine. So wily EPC contractors from around the world doing work in Africa understand that process. So they make sure that they're making profits up front, they make sure that they're getting large advance payments up front, etc., etc. They know the game. What governments do and owners want to do is push all the risk back to the contractor. Does it work? We have common things, for instance, where contractors sign contracts where the owner says you have an obligation to obtain all permits, including visas for anybody that may come here, etc., etc., etc. You must apply for this, you must apply for that. Sorry, how does that make any sense, getting the contractor to do that, when the government is the entity that you're contracting with and controls that entire process? So it's time for doing contracts in Africa where people start looking to say, we've got to have a more collaborative attitude to making it work. If we go back to a philosophy which we all are supposed to live by, is that we're doing it for the right reason. Do you need schools? Yes. We should be building schools, the best schools, and educating our population. If we need energy and we need power generation, we should be doing that for the benefit of all at the end of the day. And until you get a collaborative approach where you get people to contractors, owners, suppliers, to sit down and say, we need to finish this project, let's work together to finish it. Let's look at those contracts that get drafted, bespoke contracts, and have a look and say, how do we amend these contracts to ensure that there's responsibility, obligations, but an attempt and collaboration to make sure we meet the date. And I can only use the example, I was involved in 3 of the World Cup stadiums. They had to finish on time. We sat there in one of the stadiums one day, and the inspectors came around. The World Cup inspectors walked in, and we were all sitting there. And our stadium wasn't really the particular one. And they looked around and they said, well, if it isn't, you ain't going to get the World Cup. All those stadiums, we built the best stadiums in the world in this country. So we can do it. There's got to be an incentive to do it for the right reason and do it to make sure the country works and that Africa as a whole, you get the growth and development that you're looking for. Thanks, Denise.
Thanks, Clive. You mentioned contracts quite a bit. So do you think your FIDIC, your EPC kind of contracts need to be relooked? Are they still fit for purpose, or are lawyers having to rebuild them clause by clause?
I think it's sometimes problems when lawyers do try and rebuild it clause by clause, but the standard contracts work. And I know the FIDIC contract, and anybody who's been involved in doing construction in Africa will know the FIDIC contracts, they work. Part of the problem that's arising is when disputes arise. And a representative of Anglo-American sat on one of the panels yesterday, and he says, I don't want this blind approach. There's a problem, there's a dispute, there's an adjudication, there's an arbitration, there's an award, there's an enforcement. You've got to think laterally, and challenging us all to think laterally. When you sit down in a dispute resolution clause, have a look at the mechanism. Does the mechanism work in the jurisdiction in which you're doing that work? It might be that mediation is very effective. It might be that mediation is not something that's ever been used in that jurisdiction before. It might be that getting representatives, senior representatives of companies to sit down and have to talk to each other to resolve issues within stipulated time periods may work. It might be that adjudication does work. It might be that people have found that adjudication is costly, time takes too long, and doesn't work, because everything ends up going to arbitration. You may have a very, very large project where having a dispute adjudication board, or as it's now called a dispute adjudication and avoidance board, makes sense. Because you get guidance of experienced people, not just lawyers. You may have QSs, you may have planners, you may have construction lawyers sitting on that DAAB. But guiding the parties if a problem arises. Looking through that, I've got a massive claim. And start saying, no, what is your real claim? Let's analyze it, and let's get on with the project. I was showing somebody earlier on and saying, in the UK, when you say there's a 28-day period to finish an adjudication from start to finish, it happens. I can assure you it doesn't happen in South Africa. So looking at your jurisdictions, there's nothing wrong with the contracts. And I say it openly, we've done contracts, it doesn't matter what it is. It can be a FIDIC, it can be an NEC, it can be JBCC, GCC, it doesn't make any difference. It's the people that are managing those contracts that make it a success or make it a failure. You can walk into your first meeting as the project director and start shouting at people. Your contractor is going to say, well, that's the way we're doing business, that's the way we're going forward. And I'll appoint, as happened in some of the projects where some of the project managers that came across to do work in South Africa on some of our power stations were 2-star generals in the American Army. And they thought they could run South Africa and projects in South Africa because they were 2-star generals. They didn't understand South Africa. So start understanding where you're doing the business, where you're doing the work, understand the culture, understand the people that you're going to be working with, and make sure that those projects are a success. And sometimes, yes, an owner's got to have an owner and a government, and I know government's sometimes very difficult, sometimes has to, put it crudely, suck it up, as do contracts. I've had a project which started in 2018, was terminated in 2019. It's here in Gauteng. 7 years later, nothing has been done on that project. And it broke down on the basis that the parties couldn't agree on a new rate for something. Over 100 million rand project, 40 million rands in the ground. 7 years later, that stuff is still in the ground, just covered with grass. As opposed to people talking and resolving and finding a collaborative approach. Simple, yes, the contract does work, but parties have got to understand the contract and work together to implement it.
Thanks.
Thanks, Des.
Thanks, Clive. Thanks for those insights. Was that a clap? Burton, you have the floor now. So Vivian mentioned some of the projects that are underway involving various states and parties, for example, the Lobito Corridor. Can arbitration realistically manage multi-contract, multi-party disputes that cut across mining licenses, infrastructure agreements, and off-take contracts, often with a state entity on one side and a consortium of investors on the other side?
Yeah, thanks, Denise. Good afternoon, everyone. I know it's late, and we're between a gala dinner, but I'll be brief. I think the short answer is yes. that the arbitration forum, wherever it finds itself, is certainly able to deal with multiple contracts across various parties, whether that's states, with investors, and then also within a particular project. And it's always good to use an example of a project, and I'll use a local one with an international investor, a Chinese investor that is looking to export manganese, and involved in that contract are multiple contracts. Sorry, involved in that project are multiple contracts, from the acquisition of the shareholding, through to the mining contractor, through to agreements with state, to funding agreements, and we're in the process with an offtake agreement. And I think the starting point is what Judge Sutherland said, or retired Judge Sutherland said yesterday, is that the courts can only handle 25% of the current capacity. Of the 100 cases that come to them, they can only deal with 25, which means we have to use arbitration. And I think I say that because that's the starting point. Without an arbitration agreement up front, it's sometimes very difficult to agree to it at the back end, because arbitration can be costly, and because the parties may not always agree. And so where you have multi-contracts, I think the starting point is that you need to have commonality in terms of the arbitration agreements. It's no use one contract referring to disputes being resolved with the ICC and the rules and the law of the jurisprudence of England and Wales will apply, whilst your mining contractor agreement provides that AFSA will have jurisdiction in terms of its international expedited rules. It becomes very difficult then to even try and deal with multiple contracts dealing with a particular contract, with a project. And so you have to, as a lawyer where you're advising, and in our instance where we're advising across multiple contracts, to make sure that there is commonality and alignment in regard to your contracts, and that every single contract has pretty much an identical arbitration clause, so that you can then proceed by way of arbitration across a multiplicity of disputes, and with one common jurisdiction and one common law that applies. And so I think that's the starting point in dealing with that. And then I think the other aspect is, how do you deal with those disputes? Because the disputes may not all arise at the same time. They may arise at the outset, they may arise 2, 3 years, 4 years in. And I think one of the beautiful things about AFSA, and in particular their international arbitration, the international rules, the Arbitration Act that came in 2017, is that it provides for these kind of scenarios, both at the outset and during the process of an arbitration, and once the arbitration tribunal has been established. And there's two real mechanisms through which that is done. The first is obviously consolidation, which is often done up front, by agreement between the parties to the multiplicity of contracts, or it may be done during the process. And during a particular arbitration, you might have a dispute on one contract at the outset, and 2 years later there's a dispute on another contract. And there is then the position and the ability to consolidate. However, I'd mention two concerns that I have, and the first is obviously when you do consolidate and you've already started, you then are stuck with your arbitrators. You're not going to reconstitute if you consolidate a new tribunal. You're going to have your tribunal that runs through. And then I think the other limitation in terms of the rules, and potentially have a discussion around that, is that the disputes in terms of consolidation must be based on the same arbitration agreement, as opposed to multiple arbitration agreements with the same seat and the same law. So that's the one aspect, which is consolidation, which is Articles 28 and 30 of the international rules of AFSA. And then you also have the ability to join parties as you go along, where you want to seek indemnifications and the like. Article 29 also provides for that. So we're well suited as AFSA, both in international and in domestic arbitrations, to deal with a multiplicity of contracts and disputes that arise between various parties, but primarily involving the same project. You're unlikely to have a consolidation where you're dealing with, with different projects, unless the state is involved. Then parties may join together to take the state on.
Thanks, Burton. So talk to me about interim relief tools that a tribunal can have. Are they effective in an example where a miner is trying to, sell its inventory during a pricing dispute?
Yeah, I think there are measures. I think historically, one has always had the scenario, and if one looks back at arbitration clauses over the years, you've usually had a hybrid between arbitration forums and the courts. And the modus operandi for many years was to either hold the arbitration in abeyance whilst a party went to the courts to obtain interim relief, to get an interdict against, using your example, against the sale of the minerals whilst the investor was looking to resolve a dispute. And so one would go off to the High Court for an urgent interdict to stop them from acting in an untoward fashion. But what we now have within the AFSA international rules is the ability to proceed on the basis of urgency. And there are various rules that deal with it, but you can literally proceed and within 48 hours have the appointment of an arbitrator that will attend to the matter and with a mandate to finalize the dispute within 14 days. I was having a chat with a colleague earlier. Sometimes 14 days is too long. And one needs relief before 14 days because I'm not sure how fast you can move a couple of thousand tons of manganese, but we're yet to see. But I think the reality is that 14 days may even be too long, and one would potentially want to curtail that to less.
Yeah.
I know in the High Court you're able to go on an afternoon, depending on the urgency, and meet the judge in chambers to say, look, we need the relief. And I think to the extent that we can amend the rules or provide for those scenarios, I think we'll go a long way to moving away from urgent relief in the High Court or any the High Court and move it towards arbitration forums.
Cool, thanks. I think just the last question that I have for you, I think this is particularly important for us practitioners, is seat selection. So seat selection specifically in these critical minerals disputes, it's quite consequential now more than it ever has been. So why should parties resist the instinct to, reach for London besides the bad weather, or Paris? And what does, Johannesburg specifically have to offer?
We're cheaper. No, I think that's one of the reasons. Look, I think the starting point is the fact that we pass muster internationally. So I think that's the first point, is that we have a great international forum. We have the ability to deal with complex disputes. We have the necessary expertise, and our rules and act are based on modal law. So we have positioned ourselves well for that. So I think that's the starting point. It's not that, Africa is inferior to the rest of the Western world, whether that's ICC or any other forum. So that's the first issue. I think the second issue is enforceability, and there's been a lot of discussion in regard to that, in terms of enforceability of awards and whether a particular state is a party to the New York Convention, and so that is applicable within South Africa. I think one of the key aspects is neutrality, particularly now with geopolitical tensions within Iran and across the globe between China and the US. I think one wants to offer neutrality in terms of a lack of trust between parties, to say come to a neutral venue, and the neutral venue would be Johannesburg, and the application of the AFSA international rules. So I think that's another good reason. And then obviously confidentiality, the fact that and that applies across the board within arbitrations, but even more so in South Africa, in that the confidential information and the nature of the dispute remains confidential between the parties. And I think that's a key aspect, especially if the parties are able to resolve their disputes. And then I'd end off where I started, and that is that is a lot more cost effective. If one compares the cost in London and Paris versus the cost within South Africa and Johannesburg, that is certainly an incentive for international litigators to come and use AFSA as a forum.
Thanks, Burton.
And lastly, having practiced and worked in both forums, ICC and AFSA, I can certainly vouch for AFSA, have experienced both sides. Not I'm just speaking about AFSA and I've never dealt with ICC. I think it is important to have practiced in both jurisdictions to be able to speak with some authority on those issues and what has been the experience. Can you say, hand on heart, that ICC and AFSA are comparable? And I think that's the same for many of us that have practiced in those, those forums.
Yeah. Sure. Thanks, Burton. I think we're going to wrap up now. I think we have one last question that I'll direct to Jackwell to just close off. So we've heard from Vivian on the regulatory reality, Clive on the project delivery challenge, and Burton on the dispute resolution tools. Does the legal and institutional architecture we have discussed today give you confidence that African states and investors can actually navigate this moment, or are we structurally behind this curve?
I would say yes, but it's a complex yes. As I think Vivian has set out from a regulatory perspective and the contractual measures in mitigating risk from a contractual perspective in a particular state with an investor or shareholder, and as Clive has set out from a project perspective, delays and all the other scenarios that goes into that and decision making, actually trying to make a simple project just get to reality and work past all the issues. And as Burton has also pointed out in terms of the choices that we have from arbitral perspective, and also looking at AFSA and the AFSA rules, AFSA international rules. I think in the broad strokes and taking everything together, and maybe speaking to everyone in the room that are lawyers, including us here, one of the important things, we spoke about critical minerals, but you must remember, for all of these projects, we need lawyers, we need accountants, we need a lot of professionals to assist, yes. And there's and it's not spoken about a lot, so there's a very fundamental protocol called the Protocol on Services. And the Protocol on Services affects all of us in the room. The accountants, the lawyers, every single one of us. And the intention behind that is you have to do all of these things to get the products into Africa, to the market, to the ports and amongst African countries. But you fundamentally know that you need service providers to also do that. You need to make sure that service providers have the ease of moving between one country to another country within the context of immigration. So it's important to recognize and that we as service providers also play a fundamental role in making sure all of these things come together. And comes down to when you have, as a service provider, and you're advising your client in respect of which seat, or how to structure the contract, always remember the principles also that we need to ensure that we act in the best interests of our own country, but of the continent, saying, when I sit around the negotiating table, do I punt for Johannesburg? Do I punt for Nairobi, or for Mauritius, or for Cairo? To say, when the seat of arbitration should be in Johannesburg because of X, Y, and Z. And you should use lawyers in South Africa, in Nairobi, in Harare, because they have the skills and expertise. And we also need to collaborate more in terms of helping each other to get to that level. But yes, I think as Africans, and in terms of, again, going back to the fundamental blueprint is, if we follow their blueprint and we all work together, and we are not driven by corruption and greed, then we're going to definitely see the laudable objective of what is set out in these documents by the politicians, and some of them have been corrupt, but they have set out these laudable objectives of getting us out of poverty, getting value addition on the continent, getting more intra-Africa trade on the continent, building the infrastructure, which just benefits all of us. Moving from a $3.4 trillion economy to a $7 to $10 trillion economy. And everyone collectively will benefit from that.
Thanks, Jackwell. Appreciate it. So yeah, thank you to my panelists, appreciate it, and our most esteemed guests. I have an announcement to make. Okay, please announce that. Okay, so the dinner gala will be at 6:30. You can only attend if you've registered. So, yeah, I don't know where it is, I can't tell you, but then it's at 6:30. All right, thank you, everyone.
Thank you.
Well done.
Thanks. It's good. Mike is still on. Thanks. Was it